They're fucking Satanists. They're Satanists. The Vatican has taken control of the District of Columbia, and I'll show you. It goes through it in detail about how the Vatican has done that. And so they're not your countrymen.
They're not.
They're foreign agents. They're engaged in treason, sedition. They need to get their necks stretched.
Yeah.
And
they're at war, undeclared war against the American people.
That's right.
And they've infiltrated our government.
Yeah. Anyways, don't get me going.
Actually, getting you going has been a source of great enlightenment over the years.
So anyways, we can go through that, or we can do that other document that Heidi did. It's called a Notice of Resignation and Substitution of Trustee.
Yeah,
this is yeah. And so there's evidence that she submitted that I don't have some of it. So, but this is pretty interesting. This is the situation where she had been convicted, okay, and sold into slavery in the Vatican's Roman so-called court. And so this is how she dealt with it. Why don't we do that? Although that other one is pretty good, but this one is different, and I don't want to be hashing over the same thing all the time.
There's no surety in this case. Let the record show there's no surety in this case. Oh, nice.
You just can get yourself out of jail.
I would think.
No surety.
Well, once you're in jail, that's really hard because you're a thing. See, the 12 presumptions defeat all of their presumptions that you're a thing and property and can be sold into slavery. Okay, because a slave is a thing.
But it's best if you do it before they get you in there.
Yeah, and so this, I'm not sure. So you can't, I don't know. But this is how she dealt with it, and they don't want to talk to her now. So it's pretty brilliant, I'm telling you. And so anyway, so this is what we'll go through today for everybody on YouTube. And there's nobody showed up yet anyway, so there's actually 6 viewers. This is a notice of special. This was done by someone who they had been in jail. They got themselves, they were out. I think they had done their time. Didn't Heidi do her time? She had done her time and she was out. I think she was on parole.
Yeah.
I think she was on parole. And when she did this, she was at home, and this is one of the things she did. She did the affidavit of life, the notice of the 12 presumptions. And this, anyway, so let's go through this here. Notice of resignation. Let's make it bigger. And I've sanitized this. To protect the identities. Okay, and I just want to make sure. Yeah, good. So, let's modify this here. Notice. Substitution of trustee. This is really brilliant. You guys are going to like this. So I just wanted to change the title of the video because then you'll be able to see it in YouTube. So this is, somebody did it. They were already out of jail, but they were on parole, and now they don't even want to talk to them about the parole. Okay, so that's like really powerful. They did this. They did the affidavit of life. They did a notice of 12 presumptions. I don't know what else they did. And there's attachments that are talked about in this notice of resignation and substitution of trustee. Because what happens is that they assault you with the trustee, and the trustee gets to go to jail as surety for the trust. You see what I'm saying? So anyways, so per 46 USC 1247, pursuant to UCC 2-301 and Internal Revenue Code 671 to 679, declarant hereby notices the following facts for the record. That the laws of equity and the law merchant shall apply to this action. That I, John Smith, am a man of the age of majority, lawful owner of John Smith, that's the minor estate. See evidence A, affidavit of ownership, attend. I think this is supposed to have a bracket here. And I attend in a non-representative capacity under special appearance. So what happened is she had this document at our meeting, and I took pictures of it, and so then I went from the pictures and transcribed it, typed it out. So when you type it out, you have to read the thing. You see what I'm saying? You're forced to read every word, and sometimes things get a little screwed up too. Anyway, so paragraph 3, that I, John Smith, have not been given disclosure / full disclosure of all material facts and may have intentionally misled and deceived in this instant matter. For example, the alleged I think it should have a bin. May have been intentionally misled or deceived in this matter. For example, the alleged plaintiff may not be the United States of America as stipulated in the organic law, the Articles of Confederation and Perpetual Union, and that the United States District Court may be a private corporation with a done.
You got too much there. Yes.
With a DUNS profile and EIN number, and may not be a judicial branch Article 3 court of the lawful government as required by the Constitution. So she's not saying it is, just it might be.
You want to just do iffy.
Yeah.
That way it keeps it where it's open for investigation.
So anyways, a notice of footer, special deposit, XXX Trust, which is probably, I'm guessing, this name right here. But I don't know. She had stuff, a lot of it blacked out. She had redacted stuff. Now, this first trust, so I, John Smith, rescind, revoke, annul, cancel, extinguish any and all express or implied contracts, general appearances on the record, pleas, agreements, signatures, representations, counsel, attorneys, agencies, warranties, etc., made to any party in regards to the first trust case number. And I can tell you that one of these she didn't redact, and that was the criminal case that she'd been convicted under. Okay? And or being the trustee thereof, okay, because that's what they do, is they assault you with the trustee and sell you into slavery. That there being no replicant bond / bond on the record, and that I, John Smith, via my estate, am the creator and the grantor / underwriter of this instant matter, and as such, I, John Smith, am the only party to have added value to case number XXX, which is the convicted one, and remain the naked owner of all any/all instruments, assets, and accounts with the right of reversionary interest therein. Okay.
What's a replevin bond?
Well, that's a real bond. Okay. That's a real bond. That's common law. Replevin is a common law word. It's used in common law. So that's a real bond. Okay. And reversionary interest, reverter, that's taken, those words are taken directly from the Cestui Que Vie Act of 1666. Okay, so they're talking about the reversionary, the reverters, the, matter of fact, why don't we pull that up here? Well, let's close some of these first of all. Close that one. It's in the so this is the affidavit of life. It's in here because the Exhibit B is the Cestui Que Vie Act. See here? Let's put this on YouTube, I suppose. Okay, so we're showing this on YouTube now. This is taken from the Affidavit of Life. This is the Cestui Que Vie Act of 1666. And if you notice here, it talks about, there's a lot of Old English in here, but the important thing talks about, so absent in themselves for many years, and the lessors and reversioners cannot find out whether such person or persons be alive or dead by reason of such lessors and reversioners have been held out of possession of their tenements for many years. So the reversioners, this is all talked about, and you can look it up in the law dictionary, the word reversioner and what that is. And that, if you turn out to be alive, well, then everything reverts to you. But the question is whether you're alive or dead or not. See what I'm saying? Cannot find out whether they're alive or dead. Now, I could see how this might apply occasionally, but they're basically just assaulting everybody with it. That's what they're doing. Anyways, don't get me going. You're going to get me going again.
It says a person who possesses the reversion to a property or privilege.
Yeah. Okay, so that's where that's taken from. So let's keep going on this. Reversionary interest therein. That I, John Smith, as grantor and naked owner, hereby actually and constructively notices this court and any and all interested parties and non-record holders of my election under the right of self-determination. Okay, that's taken from the International Covenant on Civil and Political Rights, Unit UN. And the revocation and resignation of the office of person, see evidence B, notice to rescind. And I don't have that one. And I don't have this evidence A that she talks about here. Affidavit of ownership, don't have that either. Okay, so notice to rescind. Hereby resign the trustee of the first trust case number, and this is the criminal action that she had been convicted in. And that I, John Smith.
I assume you're a trustee of the case.
Yeah, well, that's what they do. They assault you as the trustee. You get to go to jail. That's in those 12 presumptions. You got to read those 12. It talks about it in there.
So they treat the case as a trust.
It's trust law.
No, thanks.
It's all trust law.
Yeah.
Everything in the courts today is about trust law. It's all about trust law. All of them. Every court case. I haven't seen one court case that they don't admit it, but they're all about trust law. They're always all about trust law. And so then if it's trust law, then you're a thing, you're a trustee, and things go to get held by custodians. Read that again. You got to read that mandatory judicial notice of 12 presumptions. Okay, it's in there. It's all trust law. Anyways, so that I, John Smith, by way of deed of trust number XXX, so this is the second one now. So she created another trust. Okay. See, evidence C, certification of trust, did a transfer assignment and conveyance in absolute form of any and all interest and possibility of a reversionary interest as a special deposit to a private trust hereinafter XXX trust. Okay. So this is the special deposit. Okay. All rights reserved. For further distribution to the Secretary of the United States Treasury for the beneficiary of the XXX Trust, the United States of America, for the express special purpose of honorably settling and terminating the first trust case number, and that's the criminal conviction. So you got to put this together with that mandatory 12 presumptions, okay? And don't read, you got to understand the one that she didn't have any of that stuff up at the beginning, okay? All it had was the 12 presumptions, only about 5 pages, okay? I went and added a whole bunch of shit in there to show that they were unconstitutional. They're just nothing but a bunch of thieves and pirates, and turned it into 22 pages, okay? That John Smith, as grantor and naked owner by way of deed of trust, XXX, that's the new trust, did name and nominate and appoint Miss Jeanette Clack, doing business as clerk of the court, hereinafter successor of the U.S. District Clerk's Office, located at 655 East Cesar E. Chavez Boulevard, room G65, San Antonio, Texas, 78206, as trustee of the XXX Trust. Okay. And being the holder of all securities and trust properties, the successor trustee and fiduciary for the first trust, and this is the criminal conviction, the deed of trust with appointment of trustee and special deposit of the trust property was registered mailed, and this is the registered mail number, to the successor, Miss Jeanette Clack, DBA clerk of the court, and a copy thereof to been faxed on February 4th, 2015. To date, the successor has not disclaimed the office of trustee and or returned the trust property. Okay, so that's the notice of trust, right? She sent it by fax, by registered mail, and they haven't disputed it or returned the trust property, which is the notice of trust. See what I'm saying? All parties should in good faith assist successor and any all agents thereof with the transfer of the special deposit of all trust property to the beneficiary of the second trust in accordance with 12 U.S.C. 95A2 and 50 U.S.C. Appendix 7. Okay, that's the Trading with the Enemy Act. To induce the honorable settlement and termination of the first trust, and that's this criminal case number, in accordance with the will of the grantor naked owner. Okay. I, John Smith, having under an election of self-determination, resigned the office of the person/agency, and as being the trustee for the first trust, case number XXX, that's the criminal conviction, shall not be enticed or compelled contrary to my expressed will. Any attempt to compel or I think that should be entice me to the same without first presenting and conveying value of subsistence in silver shall be deemed enticement into slavery and involuntary servitude and direct and
It didn't sound right there.
and I know I'm trying to think of what in direct violation. Okay, we'll just add in the word violation. of divine, domestic, and international law, a violation of internationally protected persons, and further deemed a violation of oath and treason against the Constitution of the United States of America by the offending parties, and all those who participate therein by omission or commission. See evidence D. Notice of motu proprio. Okay, I do have that. She gave that to me.
What on earth is motu proprio?
I can show it to you right here if you want to see it. Let's share this with YouTube. Okay, this is like, she is brilliant. I tell you, she nailed it here. I'm telling you. I added that. This is one of the things I've added in to that 12 presumptions. So this is the Holy See. Whoops. Apostolic letter issued by Francis on the jurisdiction of the juridical authorities of Vatican City State in criminal matters. And it's kind of all interesting and everything. And I think the most important part right here is paragraph 5. This is the part that I put in. When the same matters are prosecuted in other states, the provisions in force in Vatican City State on concurrent jurisdiction shall apply. So concurrent jurisdiction, which means that if the same matters are prosecuted in other states, as in maybe the District of Columbia, Vatican City's concurrent jurisdiction applies.
So they both have jurisdiction?
Yeah, exactly. Concurrent jurisdiction. Exactly. It's what you're being exposed to right now. The concurrent jurisdiction of Vatican City. And you could actually make this argument and use this as evidence. That might be something to think about.
Yeah.
I can send it to you if you want.
Yeah, please do.
She had this as Exhibit D, and this was issued, and it became effective in for September 2013. So they're subjecting you to their satanic religious ceremony. This is the proof right there. This is the Vatican. Anyways, so let's go back to the Word file. So this is evidence D, notice of motu proprio, that I, John Smith, require all parties to take mandatory judicial notice of the C evidence E's, notice of rebuttal. I don't have that. Any further claims, warrants, obligations, etc. for John Smith and or for the first trust, that's the criminal conviction, or deemed accepted. Let's change that. Are to be deemed accepted and shall be delivered forthwith to the successor, Miss Jeanette Clack, who brings us as the clerk of the court, for immediate conveyance to the second trust for honorable settlement thereof. She come up with this stuff. I don't know where she come up with it.
Very creative.
She's brilliant. Request for stay of proceedings for declaratory judgment. How many pages is this? This is only 5 pages. We're almost done. I thought it was more pages than that. Maybe not. that should any party present claim that I, John Smith, am not a man, as created by God, or do not have unalienable rights, and or do not have the right of self-determination, and or am not the grantor of the first trust, and or that I'm not public property, or that I am public property or can be compelled to perform involuntary servitude as trustee for the first trust, then the execution and settlement of Trust 1 may require a stay of proceedings to allow for a hearing for declaratory judgment and or a constitutional challenge to determine of my status and rights on and for the record. So she's given him an out. This is brilliant, I'm telling you. If I'm not a man or a woman, if I'm not created by God, let's have a hearing.
Right.
Let's decide.
I like it.
Yeah, no shit. If I can be your slave,
Show me.
Yeah.
So she's going the extra mile. If they don't do it, then
Yeah.
she's free.
All rights reserved to amend without leave of the court, and under penalty of perjury without the United States, pursuant to 28 U.S.C. 1746(1). By third party of interest intervener under special restricted appearance. Okay, and so that's her. She signed that, I guess. I, the undersigned, state that see, I haven't done anything. I mean, I'm making fixes. I'm fixing this because I basically typed it in from the pictures that I took, so there was errors. Anyways, I, the undersigned, hereby state that I have firsthand knowledge of all the facts as stated herein. I'm competent to testify to matters as such, and that anything stated herein based off of information and belief, I believe the information to be true to the best of my knowledge, and that this verification is made under penalty of perjury without the United States, pursuant to 28 U.S.C. 1746(1). That's outside the United States, outside the District of Columbia, basically. By third party interest intervener, okay, that's her again, the living woman. Under special restricted appearance, non-domestic male, care of notary acceptor. So she has a notary set up to accept any service. So that's really smart too. She's brilliant.
So does the notary send this out too?
No, she could actually mail it out. Okay,
But they'll have the notary receive it.
but the return receipt for it has to go through the notary, because the notary is a third party, is an officer of the court, and
so you can still get a notary certificate and non-response.
exactly. Dover, Delaware, near the 19901, and that's it.
A notary certificate of non-response.
Yes.
That's a document of the court, since the notary is an officer.
If they don't respond, and a notary, and you have a notary that can certify,
And they're supposed to send it to the notary.
then they've and
Yeah.
then it's a judgment. That's how you get what called a
Yeah.
nil dicet judgment,
Yeah.
and it's a default judgment against them. And the notary, they can't say a notary's a liar. They can say you're a liar, but they can't say the notary's a liar.
And if they don't respond, the notary will so state.
That's right. There was no response.
Wow.
Anyways, so that's about it for this. This is pretty slick what she did, and it's only 5 pages. And
Where would you use something like that?
again, this trust, the first trust case number is when you're convicted. She was on probation, and the probation went away. See that Roger, what's his name, Milligus or whatever?
Hilliard?
That was at the meeting yesterday.
Yeah, is it Hilliard?
No, Milligus.
Hillier.
Well, whatever it
Roger's
is.
first name.
Yeah. He could use this,
Yeah.
but he'd have to know about these other documents. Notice to rescind. He needs to know what that is. Certification of trust. What exactly is involved with that? Anyways, it's pretty slick. I'm telling you, she's brilliant. This is brilliant. I sent this to Bonnie today.
Oh, you talked to Bonnie.
Yeah, she called and had a nice little chat with her. She's doing good. She's in Arkansas. She lives in Arkansas now. And so
Yeah.
she was interested in the exceedingly. And I guess Mike had already turned her on to it. She had some questions about it. And I told her about this affidavit of this 12 presumptions. And I said, and this notice of resignation. I said, you can, that and that affidavit of life, you can, I think you can turn that shit that went on with you, turn it all off, with this stuff. But anyways, so I sent it to her. So we'll see. We'll see what kind of questions they have on YouTube.
I see you have the sword and sovereignty stored in your computer.
Sorry?
I see that you have the sword and sovereignty.
Oh yes.
By Vieira.
Uh-huh.
Yeah.
Yeah, that's a good book. I've got the PDF version. Yeah. The state can be any state, definitely. It is broad, and I wouldn't worry about it. It's whatever they think it is the way I would look at it. Anytime the word state is, if they think it's them, then it's them. And if they don't, then it's not. It's that simple.
Could be state of mind.
Oh yeah. Yeah, but no, this is talking about a state, a political state.
Oh, okay.
Again, that goes to that Vatican document, right? See here where it says when the same matters are prosecuted in other states, which means District of Columbia or United Kingdom. You see what I'm saying?
Yeah.
See, those are dependent states of Vatican City.
Yeah, even
And
though it's a district, it's still a state for Vatican.
That's what I say in this in my modified. Matter of fact, why don't we go through that again? We got time. Let's find it. Oh, I know where I put it. It's in here. This is the PDF, so this is the final version. And whoops, not that one. Okay. There we go. Okay, so this is the final version that I actually filed this. I sent it to the federal court. It's mailed it today. So I'm going to contact them. I'm going to wait till it gets there. And once they get it, then I'm going to call them up and tell them I want a certified copy. And so.
What document is that?
This one right here. Mandatory judicial notice of 12 presumptions. So I made a lot of changes to this after we did our event yesterday, because we talked about this yesterday at the Tuesday meeting. And I made a huge number of changes. I turned it into basically an affidavit here. All facts stated herein are true, correct, complete, not hearsay, not misleading, were admissible as evidence, if not rebutted and proven inaccurate, and if testifying, I shall so state. I'm a flesh and blood man and a sovereign individual in a collective capacity with other sovereigns. I have standing capacity to act in the lawful matters herein. I have personal, executive, and documented knowledge of the facts stated herein. I have no first-hand knowledge of my date of birth, except that I was told that I was born on or about the year 9957. Any evidence anywhere about my birth is hearsay and inadmissible as evidence in any court, because both of my parents and the attending physician at the time are now dead, and I have not had the opportunity to cross-examine them in court to determine the veracity of their evidence. Having said that, I do remember finishing high school in the year 1975. Therefore, I'm well past the age of majority. In absence of the evidence to the contrary, I'm a free man on the soil of Texas and other American states from time to time, and devoid of any knowledge of surrendering or volunteering myself as a government employee or to the armed forces of any country, and devoid of any knowledge of surrendering myself to the District of Columbia or their U.S. citizen scam or their Trustee trust scam or their Vatican corporation or fictitious entity scam, as found in the affidavit of corporate denial, which is recorded with the Pinal County Recorder at fee number 2013 032373, and hold any respondents to the strictest proof to the contrary. In other words, if you got evidence otherwise, you better prove it. I have many good and honorable servants that work for governments on Turtle Island at various levels, and I have no idea what they get paid. But in my opinion, it's not enough, because we need people to hunt down thieves and murderers and keep the peace. And I'm cognizant of my duty to come to their aid when needed. But when they perjure their oaths and engage in unlawful activity, it's my duty to bring their crimes to light, to do everything I can to make sure they're brought to justice. The use of any statutes, codes, rules, regulations, or court citations within any document created by me at any time is only noticed that which is applicable to government officials, and is not intended, nor shall it be construed to mean that I have conferred, submitted to, or entered into any jurisdiction alluded to thereby. I got all this stuff from other people. It's not my. This is brilliant, though. This stuff is brilliant. Will Livingston ratified this Constitution for the United States of America on behalf of New Jersey, 1787, is my fourth great uncle, which means that I am posterity, as found in the preamble, to secure blessings of liberty to ourselves and our posterity. And I'm entitled to right of blood, and no civil law can destroy right of blood, because all the laws of Congress and all the laws of Texas are civil laws. And this is a maxim: the right of blood and kindred cannot be destroyed by any civil law. There we go. And this court is operating under authority which is derived from me as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. And that's another Bouvier's Law Dictionary maxim of law. Therefore, it's impossible for me to give any of these wrongdoers or their bar member handlers of this court any authority over me. And John Marshall, Chief Judge of the Legislative Inferior Supreme Court of the United States, agreed and said it's impossible for me to confer sovereignty which will extend over me. And that's McCullough versus Maryland. I won't read it. And I'm exempt from these wrongdoers and their Vatican corporation and their bar member handlers, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that's Kalanakoa versus Polyblank. And I require this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary, notwithstanding. Article 6, Clause 2. And we, the people, fail to be U.S. citizens because the 14th Amendment U.S. citizen failed to exist when the Constitution was written. And BAR is an acronym that stands for British Accredited Regency. And all bar members are appointed by Inns of Court, which is located in the Pope's owned and operated dependent city-state located in the city of London, called the Kingdoms of England and Ireland, now known as the United Kingdom and the Crown, since the concessions of England to the Pope, 1213. And there's the quote from that. We will establish perpetual obligation and concession. We will establish that from the proper and special revenues that are aforesaid kingdoms from all the service and customs which we ought to render for them, saving in all things the penny of St. Peter. The Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 namely for the kingdom of England, and 300 for the kingdom of Ireland. Because King John gave them to the Pope and agreed to rent them back for 1,000 marks sterling per year. And this is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of Pope. And not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. Which means all bar members are foreign agents of the Vatican, which is why they're here under the foundation of the Federal Bar Association at 35 U.S.C. 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945, and the Pope's owned and operated dependent city-state in the City of London called United Kingdom, and the Crown created the Cestui V Act of 1666. And this is, again, Tomlin's Law Dictionary. That dictionary's just got some real gold in it, I'll tell you. Yet still was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they're driven out of all their former holes, they devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fees to the use of the religious houses, thus distinguishing between the possession and the use, and use being usufruct, and receiving the actual profit, while the season of the land remained in a nominal fee, who was held by the courts of equity, then under the direction of the clergy, to be bound in conscience to account to assist to use for the rents and emoluments of the estate. Well, that's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. It's still the foundation of modern conveyancing. And the use is usufruct, which was brought into America first with the Pope's 1871 Municipal Corporation at 16 Stat 419. Civil law, Roman civil law are convertible phrases, meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law. And that's Black's Law Dictionary, 4th Revised Edition. And then the Code of Law for the District of Columbia in 1901, where the legal estate to be the cestui use. 31 Stat 1432. Which is now codified at 31 CFR 363.6 and are unconstitutional because municipal law is the law of the dependent papal ecclesiastical city-states. The appellation municipal was originally confined to the laws of the municipia, or dependent states. And that's Encyclopedia Britannica, a New Dictionary of Arts and Sciences, 1771, Volume 2. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, between Tuscany, Modena, and Lombardy on the northwest and Naples on the southeast. Area is 17,822 square miles. Population in 1833, 2.7 million. Capital, Rome. Population, 153,000. Government, an elective monarchy. The Pope, for the time being, the absolute sovereign, with a consulting assembly of cardinals. Waterston, that's taken from Waterston Encyclopedia of Commerce and Mercantile Law, 1836, page 582. Rome, the capital of the Pope's territories and of Italy, and anciently the Milrus of the Roman Empire. And was also called canon law. The civil or Roman and canon law, though they're not perhaps to be deemed proper parts of our written law, have undoubtedly had the greatest influence in Scotland. The power exercised by our sovereigns and judges have been justified upon no other ground than that they were conformable to the civil or canon laws, and a special statute was judged necessary upon the Reformation to rescind such of their constitutions as were repugnant to the Protestant doctrine. From that period, the canon law has been little respected, except in questions of tithes, patronages, and some few other articles of ecclesiastical right, but the Roman continues to have great authority in all cases where it is not derogated from by statute or custom, and where the genius of our law suffers us to apply it. And Encyclopedia Britannica, or the New Dictionary of Arts and Sciences, 1771, page 883, which is now the Vatican, and it continues to this day. And this is the Lateran Pact, Article 4, 1929, with Hitler and Mussolini. Actually, it was Mussolini in the Vatican. The Lateran Pact was Mussolini in the Vatican.
Italy.
Yeah. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as pertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. And unconstitutional because of Article 1 and Amendment. Congress shall make no law respecting the establishment of religion. And is unconstitutional because this was what precipitated the War of Independence. This is the causes and necessities for taking up arms, 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. And for altering fundamentally the form of government established by charter, we saw the misery to which such dictatorship would reduce us. And the organic law of the Declaration of Independence shows it was listed as reasons for Declaration of Independence from the Pope's owned and operated tyrant. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses. Now, they might have been doing that, but that also alludes to the Sesta KV Act. For imposing taxes on us without our consent, that's the Sesta KV Act. For depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government. He's abdicated government here by declaring us out of his protection and waging war against us. That's what they do in Roman law. It's all about warfare. And he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, can only be talking about the Pope's Roman law. And the minor estate, 31 CFR 363.6, is an entity, because an entity includes the estate of a living person, such as an incompetent or a minor. And a minor can be anyone over the age of 18 years who's failed to take control of the securities in the Treasury Direct account. And the minor estate is a fiction of law which was invented by the Roman praetors under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, page 520. Fictions of law. Fictions were invented by the Roman praetors who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fiction is the resource of weakness, which in order to obtain its object assumes as a fact what is known to be contrary to truth. When the legislator decides to accomplish his object, he need not feign, he commands. Fictions of law owe their origin to the legislative usurpations of the bench. And that's and fictions of law right here owe their origins to the legislative. So it's legislative. When the judge is not a judge, he's a legislator. And so, which is necromancy and satanic. And that's Deuteronomy 18:10-12. I won't read that. Which puts you under the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever of such district, not exceeding 10 miles square, as may by cession of particular states and the acceptance of Congress become the seat of government. To deceptively assault people with a quasi-contract, assumption in its action of tort, assumption of suit is transformed into an action of contract, being afterwards a remedy where there was neither tort nor contract, being at first upon an express promise, it was afterwards upon an implied promise, and even upon a fictitious promise. introduced as a special manifestation of the action in the case, it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account, with case upon a bailment, a warranty, and bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts. See? So these Roman praetors just dream that shit up. Both in Roman and English law, there were certain obligations which were not in truth contractual, but the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of a fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it, which requires the Pope's minor estate. 31 CFR 363.6, U.S. citizen or other fiction. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the District of Columbia expand to anywhere on the planet. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even when one of the several states, as though the district expands for the purpose of regulating citizens wherever they go throughout the states of the Union. And which is why in the Kavanaugh hearings, when he was being interviewed for the Supreme Court appointment, they asked him, "Can we go after a U.S. citizen in Afghanistan?" And he said, "Yes, you can." And because plenary power, remember it talks about through their plenary power right here nationally, and because plenary power is a dictatorship under the Pope's Roman law. Plenary jurisdiction, the court's full and absolute power of the subject matter and the parties in the case. Plenary is full, complete, entire. Plenary, full, complete in the courts of admiralty and in English ecclesiastical courts. Causes or suits in respect of different course of proceedings are termed plenary or summary. Plenary is a plenary power. A plenary authority is a complete and absolute power to take action on a particular issue with no limitations. It's derived from the Latin term plenus. Plenary power, complete hour with a particular issue with no limitations. It's often used to describe the commerce power of Congress under the Commerce Clause, Article 1, Section 8, Clause 3. Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress, which is also a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial. So think about it. The judge is not a judge, he's a legislator, and he's order of commitment to Joe Blow. That sounds like a named individual, and it's a non-judicial trial. Bill of attainder means legislative acts, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. Because judges only hold office during good behavior. This is Article 3, Section 1. The judges, both the Supreme Court and inferior court, shall hold their offices during good behavior. When they're in good behavior, they're a judge. Otherwise, they're not a judge. And judges in bad behavior are engaged in fraud upon the court. Fraud upon the court is fraud which is directed at the judicial machinery itself. It is not fraud between the parties or fraudulent documents, false statements, or perjury. It is where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function, where the impartial functions of the court have been directly corrupted.
That would apply where the judge said he couldn't dismiss the case, right? Because you get fired.
Well, it's certainly a conflict of interest, he's saying right there. And operating as an administrative clerk, masquerading as a judge under Roman law, is bad behavior, which are non-judicial proceedings. Because wherever a statute's involved, the Pope's fake judge is actually a bought and paid for clerk masquerading as a judge. When acting to enforce a statute and subsequent amendments to the present day, the judge in municipal court is acting as an administrative officer and not in a judicial capacity. Think about it. Administration is talking about the minor estate. Anytime it's administrative, it's the minor estate they're dealing with. Courts administrating and enforcing statute do not act judicially, but merely ministerially. but merely acts as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk. Judges have become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. They're bought and paid for. And bills of attainder are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment, which says Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law, also known as canon law, and because they have imposed martial law rule. Again, that's the cause of necessities for taking up arms, 1775. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits to deprive us of the accustomed or inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. With the bankruptcy emergency, it's an established fact that the United States federal government's been dissolved by the Emergency Banking Act, March 9, 1933. Notice the date. Declared by President Roosevelt being bankrupt and insolvent. HDR 192, 73rd Congress, Session June 5th, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States in the official capacities of all United States governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only. And this is U.S. Senate Report number 93-549, dated November 19, 1973. Since March 9, 1933, that's the same day it went into bankruptcy. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. Because martial law rule is the law of emergency and necessity. This is Ex parte Milligan. There's three kinds of martial law. Full martial law, when actually invaded by a foreign enemy or there's an insurrection and troops are put on the street. Martial law proper is the law of the armed forces. When a sergeant tells a private what to do, it's enforced by court-martial. And martial law rule is the law of emergency and necessity. It's used during peace times, and it can go on indefinitely. And that's Ex parte Milligan, and is quoted in this non-ratification of the 14th Amendment by Judge H. Ellen of the Utah Supreme Court. And the Pope's bar members on the bench tell you I can do anything I want in here. And this is, again, in that non-ratification of the 14th Amendment. The whole quote is, this is a war over the intrusion of the civil law upon the common law. The court in Diamond v. Harris calls civil law, which is statutory law, superior equity. And this is the quote out of that Diamond v. Harris. It's difficult to see how the courts of the state are to ignore the common law as a rule of decision when it's made so by statute and adopt a civil law, even though it have the merit of superior equity. And he goes on, in the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. No, equity follows common law is what they're talking. That's what the law is, common law. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. Because under martial law rule, equity does not follow common law. And this is, common law is Christian. Every system of law known to civilized society generated from or had as its components one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws its subsistence from the latter, that's the Christian. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. But when you have martial law, there is no common law, and equity can do anything it wants, which makes it satanic, because Satanists are using the Pope's Roman law of capitis diminutio, capitis diminutio maximum, meaning the maximum loss of status through capitalization. The highest and most comprehensive loss of status has occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away all the rights of citizenship and all family rights. To populate the prisons by selling people into slavery. He, the prisoner, has a consequence of his crime not only forfeited his liberty, but all his personal rights which the law and its humanity affords him. He is for the time being a slave of the state. And because of the administrative proceedings under the Pope's Roman law, there are more people in prison in America as a percentage of the population than there are in communist China, or in the Soviet Union, or in the worst dictatorship in history. And if there were Christians here, the bar members doing it would get their necks stretched. If a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. And the Innocence Project estimates that 60% of prisoners are innocent. But it's such good business for the Vatican and the Roman law so-called courts, which is one of the grievances of the organic law of the Declaration of Independence, 1776. He's plundered our coast, ravaged our coast, burned our towns, and destroyed the lives of our people. How do you think, when they say destroyed the lives of our people, how do you think they did that? They did it by putting them in prison. All of which has been planned and orchestrated by the Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley in the Chicago Daily Tribune, May 5th, 1903. And the Pope, the Vatican, now owns and operates the bankrupt 1871 corporation, as evidenced by the Roman Achaia military staff that's planted on all conquered nations, that's sitting on the right side of the Speaker's podium in the U.S. House of Representatives, and the two Roman fascia, bundle of rods bound into a weapon symbolizing under the rule of a single man, that are on the wall on each side of the Speaker's podium in the U.S. House of Representatives, which is why Nancy Pelosi, when she was Speaker of the U.S. House of Representatives, told the members of Congress, we can't read this bill until after we pass it, because she was taking instructions from her Vatican handlers, all of which is evidencing the fact that the 1871 corporation currently operating in the District of Columbia is a Vatican-dependent city-state. And there's a picture. And there's the Roman Achaia military staff, and there's the two Roman fascias on each side of the Speaker's podium. And the Vatican's Pope Francis recently issued an apostolic letter about the jurisdiction of judicial authorities in Vatican City, state, and criminal matters that talks about concurrent jurisdiction in other states. And that's paragraph 5 that we talked about. When the same matters are prosecuted in other states. Gee, that sounds like maybe the District of Columbia, or maybe the Kingdom of England and Ireland, or the United Kingdom, or who knows where else. The provisions enforced in Vatican City State on concurrent jurisdiction shall apply. And that entered into force on the 1st of September 2013. And the Vatican's Pope Francis came and addressed his owned and operated Congress on 24th of September 2015. And the Pope's satanic bar members are assaulting people with their Roman fiction of law, minor estate, sustice usufruct, trust, which is necromancy, with all the following presumptions that are rebutted as follows. And so then I go through the presumptions. It took me a while to get there, didn't it? 15 pages. But, and so we talked about this. This largely hasn't changed. There's been a few changes. I added in some stuff about there's no surety in the matter. And so, but anyways, and I added in on behalf of the Vatican's corporation. So this is any person acting as the agent for a nameless, faceless corporation is wholly personally responsible for their actions on behalf of the Vatican's corporation. yeah, so I threw in some stuff like that. Anyways, right here, there's no surety in this matter.
Are you going to do a separate YouTube video on this, specifically on the 12 presumptions?
Well, I did one yesterday.
Okay.
I mean, do you want to go through them again?
I thought they were stunning. Nobody can absorb all of that on one going through.
Okay, well, we can go through them again if you want. This is what I mailed to the federal court today. And I want to get it filed, and then I'm going to ask the federal, I'll call up the clerk, and I'll pay whatever they want to get a certified copy mailed back to me. And so, anyways. Okay, well, the presumption of public record is that any matter brought before a court. Let's see what they're doing on YouTube. Maybe they've got some questions. Oh, look at that. Somebody sent me a donation. That's very nice. Thank you very much. Zoom out a smidgen. Okay. Okay. Let me see if I can fix that. Thanks for bringing that to my attention. There, that should be better. What I can do is I can upload the Word file for this to, and then you can manipulate it all you want. Okay, I'll upload it to Google, and then I'll put a link to Google Docs on the in the show notes for this video, and you can have the Word file, but don't be asking me for permission to get access to it, okay? That's not the way it works. The way it works is you download the file onto your hard drive, and you can do with it what you wish, okay? You don't need access, and I'm not going to give any permission to access it. You just download the file onto your hard drive, and then you can do what you want. Good. I'm glad you like it. Anyways, so let's keep going. There's people here that want to go through the presumptions again anyways. And what I'll do is I'll upload I'll do the Word file before I leave. I'll upload the Word files to Google Docs, because this is the one I filed in federal court today. And so this is like the final product or what I filed anyways. And I'll probably file it again in other courts. I'm probably going to, file it. I might even record it in a county in Arizona. I think that getting this out is like really important. Anyways.
Please make some comments about the private bar guild. The courts are not what we think they are.
No, of course not. No, they're private bar guild. You know, I think I'm going to get myself a coffee. I'll be right back. They got iced coffee up front, so I think I'll get one. Although, damn, if I do that, I might not be able to go to sleep tonight. Maybe I won't. I won't be able to go to sleep. Anyways, so let's go ahead. Let's go through this. The presumption of public record is that any matter brought before a court is a matter for the public record. Remember, at the very beginning, I talked about the bar and how Inns of Court has exclusive privilege of appointing men to bar. Inns of Court is one of 4 law schools located in the city of London that's owned and operated by the Vatican. Okay?
Yep.
So anyways, so they're a private bar guild. The presumption of public record is that any matter brought before a court is a matter for the public record, which, when in fact it is presumed by the members of the private bar guild, is a private bar guild business matter. This presumption is rebuked and rejected and is hereby demanded. The matter is to be on the public record. So, and Heidi's 100% right, okay? You frame the kind of court that you have by the issues you bring up, okay? And so the purpose of this is to put them in the position that they have to honor their oath of office, okay? and put them in the position they can't do this stuff. If you don't say anything, then they'll just go ahead and do it, and you won't know what the heck happened. You see what I'm saying? And so when you expose them, well, now they can't do it because you're telling them that they're doing it, and now they have to be honorable. See what I'm saying? They're nothing but a bunch of, don't get me going. You're going to get me going now. Okay, let's keep going here. The presumption of public service, and that all members of the private bar guild who have all sworn a solemn oath to their guild and then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. This presumption is rebuked and rejected. The claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. The possibility of this matter being a private matter is rebutted. All persons engaged in the matter at hand are deemed to be in public service as public servants. The presumption of public oath is that all members of the private bar guild acting in the capacity as public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartially, and fairly as dictated by their oath. It is openly challenged and demanded the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. It is openly challenged that such individuals must recuse themselves as having a conflict of interest and cannot stand under a public oath. So you're telling them, you gotta be honorable in this or recuse yourself.
Can you make a motion for the judge to recuse himself?
Usually what happens, I've heard, and I don't know, but usually what I've heard happens is when you ask the judge if he's got a conflict of interest, he'll just recuse himself. Anyways, it is openly challenged as I got that. Such individuals must recuse themselves as having a conflict of interest and cannot stand under the public oath. The possibility of this is rebutted, and all public servants acting on behalf of this matter are required to state all sworn oaths, both public and private. In other words, you're asking them to tell us your oaths.
Yeah.
They'll never do that. That puts them in the position, you know what, I think I'm just going to recuse. Anyways, the presumption of immunity is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn the public oath in good faith are immune from personal claims of injury and liability. It is openly challenged and their oath demanded that the presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors, and magistrates are immune from personal accountability for their actions. This is absolutely rebutted. Any person acting as an agent for a nameless, faceless corporation who is wholly personally responsible for their actions on behalf of the Vatican's corporation, all actions incurring any degree of injury will incur notice of liability, including severe financial penalty. The presumption of summons is that by custom a summons unrebutted stands, and therefore one who attends court is presumed to accept the position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons, unless the summons is rejected and returned with a copy of rejection filed prior to choosing to visit or attend jurisdiction and position as the accused and the existence of guilt stands. There's a guy that I know that rejected a summons, and he took it down to the court and filed it into the court. You got to do it within 3 days. Your offer contract is rejected. You see what I'm saying? And the case disappeared.
It's an invitation.
Yeah. This presumption is absolutely rebutted on this occasion, on past occasions, and on all future occasions. However, at no time was I absent nor silent with regard to the matters at hand. The present presumption of custody, this is talking about jail, is that by custom, if a summons is not rebutted, it stands as therefore one who attends court is presumed to be a thing, and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, not flesh and blood soul-possessing beings. That's why when you do that affidavit of life, it creates a major problem for them. Unless this presumption is openly challenged and rejection of summons and or at court, the presumption stands you are a thing and property and therefore lawfully able to be kept in custody by custodians. This presumption is absolutely rebutted. I am alive and well and a man. I'm not in custody by custodians or guardians. I'm not a thing. I am not the property of the court. Under no circumstances may I be detained in any way whatsoever, not at any time, past, present, or future. There is no surety in this matter. The presumption of the court of guardians is the presumption that you may be listed as a resident of a ward of the local government area. You're a pauper and therefore under the guardian powers of the local government as its agents as a court of guardians. Unless this presumption is openly challenged to demonstrate you're both a general guardian and general executor in the matter before the court. See, this is talking about trusts again. The presumption is rebutted that I am by default a pauper, a lunatic, and therefore must obey the rules of the court of guardians, the court of the magistrate's court. This presumption is absolutely rebutted. I am at all times a man, sui juris, and have possession of much more than 21 silver eagle coins with a face value of $1, and therefore fail to be a pauper. There is no surety in this matter. The presumption of the court of trustees is that members of the private bar guild presume you accept the office of trustee. That's who goes to jail. As a public servant and government employee. Okay, trustee, public servant, government employee, it's all the same thing. Just by attending the court. As such, courts are always for public trustees by the rules of the guild and the court, unless this presumption is openly challenged to state you're merely visiting by special attendance to clear up the matter, and you're not a government employee or a public trustee in this instance. The presumption stands and is assumed as one of the most significant reasons to claim jurisdiction simply because you appeared. I can't tell you how many times I remember Bonnie going into court and was challenging, it was a divorce court. And the judge said, you're here, aren't you?
Yeah.
Anyways, this presumption is absolutely rebutted. Absolutely no jurisdiction at any time may be claimed by a private bar guild and the court over me. The office of trustee is rejected. The role of public servant and government employee is rejected. There's no surety in this matter. I'm entitled to common law, not Roman law, as described in Article 6, Clause 2 of this Constitution for the United States of America, because the law of the land phrase and is a convertible phrase with the phrase common law. The principle that no person shall be deprived of life, liberty, or property except by due process of law did not originate with the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to in Chapter 29. Confirmed on the 19th day of June, 1215, declared, no freeman shall be taken or imprisoned or deceased or outlawed or exiled or anywise destroyed, nor will we go upon him nor send upon him, but by the lawful judgment of his peers and by the law of the land. It has even been said that the principle was known before Magna Carta and that was originally designed to secure the subject against arbitrary action of the crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in common law, and that's Book 16, American Jurisprudence, Constitutional Law, Section 543. And common law and the law of the land has always been here long before the government was. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. Long before, that's what antecedent means. And that's Hale versus Hinkle. The presumption of government acting as two roles, as executor and beneficiary, is that for the matter at hand, the private bar guild appoint a judge/magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust for the current matter, unless this presumption is openly challenged to demonstrate you're both a general guardian and general executor of the matter before the court. The presumption stands you are by default a trustee and therefore must obey the rule of executor, judge, magistrate. The presumption is rebutted. I am a man. Your minor estate was created by fraud and deception by the Pope, and the Pope's owned and operated Crown of England, created the Cestui V Act of 1666, and I require that the minor estate be dissolved and liquidated immediately. And I don't care what you do with the fake money in the Treasury Direct account, because you can put it up your rectal orifice for all I care. There's no surety in this matter, but I demand that it be dissolved and liquidated immediately. The presumption of the executor de sans tort is the presumption that the accused does not seek to assert his right as executor and beneficiary of their body, mind, soul, living man. They're acting as an executor de sans tort, or a false executor, challenging the rightful judge as executor. Therefore, the judge magistrate assumes the role of the true executor and has the right to have you arrested, detained, fined, forced into a psychiatric evaluation, unless this presumption is openly challenged by not only asserting one's position as executor, as well as questioning if the judge or magistrate is seeking to act as executor de sans tort. The presumption stands, and a judge or magistrate of the private bar guild may seek the assistance of bailiffs or sheriffs to assert their claim. This is rebutted. Under no circumstances may the judge attempt to assume the role of executor, and before any personal attendance before court is undertaken to discuss matters at hand, the judge will need to put in writing that this is clearly understood, fully disclosed, and acknowledged. This is a false presumption. There is no surety in this matter because it's a fraud and a nullity. I want nothing to do with your minor estate or your Roman law / canon law, and consider it satanic and an offense before God. You can put it up your rectal orifice. The presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue property. Therefore, the judge magistrate as executor has the right to have you arrested, detained, fined, forced into psychiatric evaluation, unless this presumption is openly challenged. To the fact that you know your position as executor and beneficiary and actively rebuke and object to any. See, I'm saying that there is no trust. Then it stands by the time of pleading. Matter of fact, what I should do is I should modify this. I already sent it, but maybe I'll have to modify the one that I got. There is no trust. When the judge or magistrate can do whatever they need to keep you obedient. This is rebutted. The law is under scrutiny for its contribution to the current state of the planet, the distribution of rights and resources, and the obstruction of divine law. In discussion regarding such matters, no privilege or deeming us incompetent is permitted. This is all the Pope's Roman law / canon law and unconstitutional as described herein. The presumption of guilt is the presumption that as it is assumed to be a private business meeting in the bar guild, you're guilty whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of trust and motion to dismiss with extreme prejudice on the public record, or called demur, then the presumption is you are guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. This is rebutted. Under no circumstances is the presumption of guilt allowed, as I am the redeemed property of my Creator, forgiven of all sin. I'm a living man, as evidenced by the affidavit of life that's filed into this case and elsewhere. Before God, angels, and anyone who reads this as a witness, I shake the dust of the earth from off my feet against all the Vatican bar members involved in this matter, and your screen for low intelligence jarhead thugs. And we'll be talking about this on Judgment Day before the one true God. Signed and sealed in red ink under penalty of perjury without your Vatican corporation, and that was the end of it. So I think I nailed it pretty good anyways, because I'm basically demurring is what I'm doing. A demurrer says there's no crime here, okay? Because you're talking trust, and I'm not a trust. You see what I'm saying? Anyways, let's go to YouTube and see what's going on there. So what I'll do is I'll upload the Word file to Google Docs. Yeah, I don't like to use those. I don't, do the GSA forums and all that stuff. Again, that's going into their system. I try and basically, that's all Roman law. It's satanic. I think what I'll do is I'll go ahead and just upload. Let's see here. Google Docs. Google Drive. There we go. File upload. Okay. There we go. So what I do, come on, you piece of crap. There we go. What I do is I make it so the editors can't change it. Come on. Anyone with the link? And there we go. Copy link. Done. Okay, so I've got the link, and I'm going to end the conference call or Zoom, not the Zoom call, the live stream, and I will immediately upload the link into the show notes, and you can download it and do with it what you wish. This will be the well, it's not the, I can do the notice of resignation too. Maybe I'll do that too. But this is more the 12 presumptions. Anyways, thanks for watching, everybody. And we're going to cancel. We're going to end the Zoom call now, and I'm going to put the link in the show notes. You guys have a good one. We'll see you later.